Welcome to Defending the Windy City with David Drwencke. In today's episode, we delve into the complex landscape of gun laws and contraband possession in Illinois. Drawing from his experience as a criminal defense attorney, David will share insights into common misconceptions and mistakes people make regarding possession laws and offer strategies for safeguarding their rights in such circumstances. I'm Sam Henninger, and I'm excited to interview David Drwencke. Thanks, David, for coming on.
Thanks for having me again, Sam.
Would you please start out with just providing an overview of the current laws and regulations regarding guns and contraband possession in Illinois?
Sure. The easy way of thinking about this in Illinois is that if you are not a FOID, which is a firearm identification owner, or a CCL, the carried concealed license carrier, that you should not be driving around with a gun. That's the kind of the short and easy part of it. The part that I think confuses a lot of people, that in Illinois, recreational marijuana or cannabis is legal for use and even possession. But if you get into the laws, you get into the nitty gritty of under what circumstances and how much and how can you transport that marijuana or cannabis, a lot of people find themselves getting into trouble with that as well. And of course, there are other types of contraband. If we're talking about methamphetamines or other types of drugs, those are just outright illegal. So if don't possess those, don't drive around with them, because that's just outright illegal in and of itself. When it comes to cannabis, again, because that's where we run into a lot of issues, is that it needs to be in a sealed compartment, odorless, in a perfect world, not even have access to that. So have it in your trunk, have it somewhere where you can't immediately reach over and grab it. Otherwise, that can be a possession charge. And that could be the basis of searching the rest of your car. And we'll certainly dive more into that. But the most important portions of this is that if it's an illegal substance that you're not supposed to have, carrying it around on your person or in your car can lead to a possession charge. And that ranges from very simple misdemeanors up to the most serious felonies, in part depending on what is that contraband, how much of that contraband do you have, what does your criminal background look like? These are a lot of the factors that go into it. But the simple part is, if you're not supposed to have it, don't carry it and don't have it in your car. If you're allowed to have it, you have a CCL or you have cannabis, pay very close attention to the laws as to how that's supposed to be transported and in what kind of container and in what portion of your car. Again, when it comes to a gun, unloaded in a sealed container, again, like a lockbox, that again, you don't have access to. The advice would be put that in the trunk. When it comes to being on your person, if you don't have a FOID or CCL, don't have that on your person. And when it comes to cannabis, again, be mindful, odorless, sealed container, probably best that you don't have immediate access to it, have it in the trunk or something like that.
A lot of caveats. What is an individual's rights when it comes to firearm possession or other illegal items under Illinois law?
Tricky. There are a lot of caveats because there are some exceptions where you absolutely can have a gun and you absolutely can carry cannabis or prescription drugs, things like that, where it's legal for you to possess them. You can have them on your person or in your pocket, or if it's a gun, in a holster or on your person. But those, you're getting really into the nitty gritty again, but the foundational point is, do you have that firearm identification card? Has the state said you can possess that gun? Having the CCL or the concealed carry license, that opens up where and under what circumstances you can carry that gun. Just because you have a FOID, F-O-I-D, doesn't mean you can just carry the gun everywhere and under all circumstances. Cannabis, again, is the one kind of a recreational drug that most people have familiarity with. Again, it is legal, and in certain amounts and in certain conditions, again, in this odorless sealed container, that you're not supposed to just have a blunt or a joint in your pocket. You're not supposed to be carrying around in a baggie. Those are inappropriate forms. So it's getting into the rural specifics of those laws, but know that you have to have the appropriate card, and that comes from the state as it relates to guns. And then as it relates to cannabis, it's usually the form you're going to buy it from a real dispensary, a legitimate, I don't want to use the word dealer, but a dispensary, or somebody's actually selling it in a legitimate way, not somebody on the corner of the street or a friend or anything like that. They will certainly be in a legal form, but you'll notice they're odorless, They're sealed. They'll be in another bag, sealed within a bag. And the dispensary, are likely to tell you, don't open this until you get home. Don't just leave this in the center console. Put this in your trunk or the back seat so you don't have immediate access and you're not giving the officers a reason to want to search your car or search you. That's some of the best advice I can give, is make sure you're doing things appropriately. And when in doubt, simply just don't do it, because the consequences can be very real.
Okay, I appreciate that. Getting a good sense of the state law there. But I'm also interested in learning more about how constitutional rights come into this, particularly the Fifth Amendment, and how that relates to individuals who may be suspected of possessing illegal items or participating in criminal activities. So how does that play into things?
Of the types of cases I handle as a criminal defense attorney here in Chicago, possession charges are one of the most common. And what that usually takes the form of, it's one of two types of possession. There's actual possession. That's where you have it literally on your person. It's in your pocket. It's in your waistband. It's in your hand. You literally have that. It's actual possession. Then there's a more of a legalese version of constructive possession, where you do not literally have the gun or the drugs on your person. You don't have them in your pocket. They're not in your hand, but they're near you. They're underneath your seat in a car. They're in a book bag that's next to you, or maybe was on your back and an officer saw you take it off and drop it or something like that. So it's not literally on your person, or literally and actually possessing it. It's constructive possession. So we treat it as if you possessed it by circumstantial evidence. Did you have access to it? Was it within an arm's reach? Could you reasonably control that item or location? Did you know that it was there? That's usually one of the biggest questions. Did the person even know it was there? And then, of course, the circumstantial evidence that a case can be built on are statements. And that's where the Fifth Amendment comes in, that you do have certain rights when you are being arrested and being interrogated by the police. And this is a common misconception that I run into, again, almost daily, where a potential client or a client will ask, hey, no one read me my rights. Does the case get dismissed? What's going on? Why is this case going on? No one read me my rights. The simplest way to describe Miranda or the Fifth Amendment, your right against self-incrimination or saying things that are going to hurt you, is twofold. Are you under arrest? And really the way of viewing that is, am I free to leave? And you can ask that question to the officer. Obviously, if your hands are behind your back, you're handcuffed, you're in the back of a squad car, good bet you've at least been detained and you're probably under arrest. The second component to that is, are you being interrogated? An officer asking you your biographical information. What's your name? Provide to me your ID. That's not self-incriminating. The officer has a right to know that information. Especially if you're driving, you should have a valid driver's license and insurance, among other things. You have to turn that over. Now, if they're going to start asking other questions that are beyond that biological things, especially if you're in custody, then you need to be provided your Miranda rights. The next component to that, I think, without getting in the weeds, is that there are times you're not under arrest. You're behind the wheel of your car. You've been stopped on the street, and the officers are asking you questions where you're not under arrest, but now they're asking you more than your name or, hey, where are you headed? Where are you coming from? Basic kind of questions. They're asking, hey, is that your bag? Is that your car? Is there any contraband in the car? Did you know there was a gun in the back seat or in the trunk? Things of that nature. And twofold, A, you don't have to answer those questions. Those aren't required. And B, answering those questions are likely going to be the foundation of how the state builds a case against you by making admissions and making statements that we can't unpack later. And that sinks the entire battleship, so to speak.
What other misconceptions or mistakes do people make when it comes to possession laws, and how can they protect their rights in those types of situations?
Some of the best advice that I can provide, because there are plenty of misconceptions, but one of the others specifically is when you're a driver of a car and you get pulled over and the officer even tells you it's for a minor traffic violation. You did a rolling stop, you didn't signal appropriately, you changed lanes, whatever. Again, the multitude of ways that you could be pulled over is that many clients don't believe that an officer can ask them out of the car. Illinois law says that they can. They can ask you out of the car for officer safety, and then the officer can view the vehicle. They can look inside the vehicle. They aren't supposed to be doing a search, but it's the plain view doctrine. If they can see it with their own eyes without actually having to go into the car, they don't have to pretend like they didn't see it. So if they see a baggie that looks like it might be drugs, or they see the butt of a gun, they don't have to have a warrant for that. They're seeing it's in plain view. They can just see that. The other bit is it relates to this misconception of not being able to be asked out of the car or be asked at least some basic biographical questions. The advice is, even if you know or believe that the officer is wrong, that they told you ran a red light and you didn't, the argument isn't going to be won there on the scene. If we need to work through the system, that's why you hire me. You hire a criminal defense attorney, because we'll unpack that. We'll go and check pod cameras and security cameras and dash cameras and body cameras that the officers may have on. But getting belligerent or argumentative with the officer right then and there is only going to make the situation worse. It never makes it better. You're more likely to get the adrenaline pumping and be angry and say something that you're ultimately going to regret, because now you're in your emotions and you're angry about the situation. And then the fact of the matter is, later on, if we ever have to negotiate on something, officers will remember bad interactions that they've had with people, just like they'll remember if it was really good. I've had that happen where the officer comes back, we're negotiating a resolution, and the officer says, he was a really nice guy. He was pleasant. I didn't have any problem with him. Work out however you want to work it out. Meanwhile, the alternative would be, man, he really gave me a hard time. Like, he was swearing at me. He wouldn't give me his identification. He started getting violent. He wouldn't put his arms behind his back. He was kicking things. He was whatever. Beyond the fact you might pick up other criminal charges, the officer will remember that, and their input is a part of a negotiated plea a lot of times. So the advice is, even if you know you're right or you suspect you're right, that's not the time you're going to be successful. So be as professional as you can be pleasant, answer what you have to answer. Don't answer what you don't have to answer, and we'll fight this out when it's appropriate in court.
Say more, if you could, about how your perspective as a criminal defense attorney has really colored your perspective on these types of cases of firearm or contraband possession.
Countless examples, because again, there's so many of these types of cases that I run into between either being drug possession or gun possession, where what a potential client or the client makes admissions to either builds the case and makes the defense possible, or it eliminates the case. And what I mean by that is, you're driving your car, you get pulled over, the officer comes up maybe with a legitimate reason, maybe not. And again, we'll unpack that at a later date. They search the car and they find something. And then my client, again, scared or nervous or whatever it may be, starts to come up with an explanation, being, oh yeah, that was my brother's. He left it there. Well, here's the problem. You think you're talking yourself out of the situation, but you just admitted that you knew that the drug or gun was there, and then you had access to it. This, for possession purposes, the case is basically done, unless we can challenge the stop or the search in some other technical way. But factually speaking, based on the evidence that would be presented to a judge or a jury, it's done. It's another example of, you didn't have to say anything. You weren't under arrest, so Miranda doesn't apply. You were just volunteering information that you didn't need to do. So there's plenty of examples where you feel in the moment you got caught, you want to talk yourself out of it, or that you're going to be able to talk yourself out of it, and you make admissions about, yeah, that is my bag in the back of the seat. Then they find a gun next to the bag. Well, we know it's your bag now, so constructively, now this gun must be yours, or at least they're going to argue that it is. You make admission about what you know is in the car or not in the car. You don't have to answer that question. If they, being the police officers, find a weapon or contraband, we'll figure out later on whether you actually knew it was there or not. But if you make an admission, the case is largely done, unless we can find a legal technicality to win on, which would be a Fourth Amendment issue. Not likely to be a fifth. The Fourth Amendment, meaning, did they have probable cause to stop you or your vehicle? And did they have probable cause to do that search? And that's a real low threshold. So trying to win on a legal technicality is difficult. So don't answer questions that you don't have to answer. I can't implore potential clients to avoid doing that as much as possible, beyond just being pleasant with the officer during the stop. Because again, there'd be another day to unpack this.
Words that are coming up in your explanations are, leave space for unpacking later as much as you can.
It's 100% true. That is exactly right. This is true of all kinds of cases, not necessarily just contraband and firearms. It's just, you've committed yourself to a story before you even know what evidence the state or the police have. when you don't answer a question, other than the basics that you're required to, if you don't answer questions, if you don't provide a statement, we have the benefit of then sitting back. And the metaphor that I like to use with clients, it's like playing cards, that once we're in litigation, the state has the duty to turn over their hand. They have to show me their hand of cards. How strong of a case do they have? Do they have video? Do they have eyewitnesses? Do they have physical evidence like DNA and fingerprints or what have you? What do they have? Sometimes the answer is not much, but boy, oh boy, my client said something that he or she really should not have. And now our hands are tied because we're committed to that. Had they not made the statement, or they had not committed themselves to a version of the facts or a story, we can be a little more creative and work through with an explanation that satisfies why the state has this evidence. So it goes back to a foundational point of, other than what you are effectively required to answer, which are those basic biographical bits and providing your license or identification, pretty much everything else you don't have to answer, or you can ask to have an attorney, or just refuse to answer in its entirety without an attorney.
In Illinois, have there been any unique cases that have set up the law as it is now?
There's a few. One of the biggest ones that we run into that is defense attorneys that relate to guns and contraband go specifically to the smell of cannabis. There's some settled case law, but now there's some new things that are working their way through the Court of Appeals, and I think eventually will find their way to the Illinois Supreme Court. And what I mean by that, with the smell of cannabis, an officer stops you, again, for something simple, stoplight, or you were speeding, or whatever it may be. They're just going to issue a ticket. At least that's their thought as they're approaching your vehicle. You roll down the window. You're doing everything you're supposed to do, license and registration. You're not volunteering any information, but the officer says that he can smell burnt or fresh cannabis. That in and of itself, under Illinois law as it stands right now, is enough now for them to search you and to search your car. I don't love that bit of case law right now because I think it's a little open-ended and kind of disproving whether somebody did or did not smell cannabis is effectively impossible. There are cases that are working through that now that cannabis is and has been legal for recreational purposes. Why is the smell of cannabis in and of itself enough to search a car when certain possession of cannabis and the actual smoking and use of cannabis is legal? It'd be like smelling a cigarette. Cigarettes are legal, at least if you're over 18, you can buy, possess, and use. So why would smelling a cigarette give rise to a search of your purse and your vehicle? I think that's where some of the logic is going. But right now, if your car or you smell like cannabis, the officer can search you or your vehicle. So where does the advice come out of that? Don't smoke cannabis and drive. Beyond the fact that you might be under the influence, you're also inviting a search of your person or your car. Make sure your car is clean and de-scented. Have things in your car that get rid of that smell, because it is pungent, it is strong, it is noticeable. So if you've been smoking, don't drive. Change your clothes. Make sure your car is clean, because again, that's the basis of searching your car, and that's when officers find guns or they find other contraband. So if you're trying to avoid that, don't smell like cannabis. Don't have fresh cannabis in your car.
Let me push on that a bit, David. I appreciate that as a caution, but let me ask you, are there actual cases coming up just off the whiff of marijuana?
There's some split decisions in this. That's why it's not quite the law of the land in the state of Illinois. But there are some cases that come back that if that's all the officer has, they've stopped you for speeding, they approach your car, they smell burnt cannabis. If that's it, if that's the only thing they have, that is no longer sufficient to search your car. Now, again, that's not the ultimate law of the land, unfortunately. Do I think that that's probably where things are heading over the next few years? Probably. Again, with cannabis being legal, the recreational use of cannabis being legal, the comparison, again, I think is apt as cigarettes, where, again, you're allowed to smoke that. You can smell like cigarettes and no one's going to search your car. But right now, yeah, the smell of burnt or fresh cannabis can be the basis to ask you out of the vehicle, to then search your car for other contraband. And even though they smell cannabis and they don't find any, but they find the gun, now we have a gun possession case that we're going to be working through.
What other advice or other key factors would you offer for people to consider when they're thinking about their rights and legal options with these types of possession cases?
Sure. I mean, beyond the fact that, of course, I'm always going to advise people, don't break the law as a foundational point as a lawyer and a member of the bar. That's the starting point. If you don't have a FOID or a CCL, don't possess that gun. There are very real and serious consequences, especially in Illinois and in Cook County, for gun possession, that just don't do that as a foundational point. When it relates to anything that's not cannabis or something that's legal as far as drugs are concerned, same idea, just don't do it. Now, for those who have or are dealing with those type of situations or may deal with that situation in the future, yeah, the foundational best practices are don't answer questions that you don't have to answer, be polite, be pleasant at the scene, because that's going to pay dividends in the long run, and not invite future issues too. The more you fight, the more the officers are going to get unhappy and then think that you have something to hide. But just enacting your rights to answer just the basic questions. Here's my license. Here's my insurance. This is my name. That's all that there is. And I'm not going to answer any other questions because I don't have to and I'm not legally obligated to, will go a long way. And then, of course, then understanding the basics of what actual and constructive possession is. That obviously, if you're going to have a gun, the worst thing you can do is have it in your waistband and be walking around and driving around with it if you're not legally allowed to do so. How do you try to soften that situation? Have it in the trunk. If you're going to carry things around, have that not on your person. Certainly don't admit to having knowledge that it's there, among other things. It goes back to not answering questions you don't have to. And then ultimately, the attorney is going to know the latest lay of the land. Have things changed recently as it relates to cannabis being the basis of a smell of cannabis to be a search? Your attorney is going to know that. The actual elements of a constructive possession case, that's what your attorney is going to know. Can look at those facts, present the best defense for you. And these are the types of cases routinely that can be won in a very fast trial if my client does themselves an awful lot of favors by not answering questions, by not admitting to things, not by volunteering information. It goes a long, long way. I think that's the best advice I can give.
I've learned so much personally just from this. So, David, I want to thank you again for lending your expert eye and letting everybody know just what their rights are, what they should be doing when they are in these types of situations, and how they could best be served by an attorney such as you.
My pleasure.
Thanks for watching Defending the Windy City with David Drwencke. I'm Sam Henninger. Like and subscribe.